Well, thank you all very, very much. I found all of that well worth my study, and I look forward to hearing your responses to some questions that I hope are respectful of your fine scholarship and your thoughtful remarks. And let me pick up and perhaps pose the first question to our last speaker, prompted by what I thought was a wonderful turn of phrase, and that is the reference to judges making clever chess moves. And perhaps I'll be disclosing my own view of myself as a trial court judge as being one of the plow horses in the stable, as compared to the thoroughbreds in the more rarefied parts of the menagerie of the judiciary. But would you say, Professor Rosen, that perhaps the public would be more understanding of the thought processes and the legitimacy of decisions if the press and, dare I say, the academy were different? Some might say more responsible. I wouldn't say that, but some might say more responsible in describing the way cases are decided and what the cases actually mean.
Judge, I can understand the frustration that you and your colleagues must feel when you work on a carefully crafted decision and see it reduced to a couple political talking points in the press. But this is less of a concern in this new and confusing media environment than it used to be. Nowadays, anyone who wants to read a decision can go online and get the original text almost in real time. There's a range of commentary, from the New York Times' thoughtful summary to specialized blogs to polarized partisan stuff. I almost feel now in this media age that it's more a question of the public's attention span rather than journalist itself. Now, there's plenty of distortion and simplistic talk, and television is a great contributor to this. The journalists have plenty of blame to go around, but it made me distressed to report the point I think you may agree with, that the public pays more attention to the bottom line than the reasons, and I'm not sure that's the fault of the press. At this point, it may just be the fact that the public has a limited attention span.
Well, when we talk in terms of an approach, an originalism versus precedent, or to try and reconcile them, who do we think the audience really is? Those of you who are advancing a particular theory or a particular thought process, is your audience 9 people, or is it the folks who might be advising the president as to who might next join the court, or does a plow horse in the field, a district court judge, need to pay attention to what you're advocating? Any of you? Professor Strauss.
Well, obviously, you all should pay attention to what I say at all times in every particular.
That was my softball.
Yeah, that's. It's a great question. Exactly, who is our audience when we engage in these debates about originalism and precedent and things like that? And it would be, I think, fatuous to say, oh, we're going to persuade members of the Supreme Court to see things our way. I mean, they've got jobs to do and work to do, and they're not going to spend their, they obviously spend their leisure time reading my stuff, but not what these guys write. I don't think that's it. I think there are kind of broader cultural currents that run through the legal culture and that make certain ways of thinking acceptable and certain ways of thinking not acceptable. Originalism actually is a great example of this. If you read what was written in the 1950s and early 1960s, critics of the Warren Court, you don't see originalist criticism of the Warren Court at all. The criticism of the Warren Court at the time was the sort of things that Jeff Rosen just suggested. They were unfaithful to precedent. They were unprincipled. They were wrong for other reasons. They misunderstood the foundations of their cases. Very little of it was couched in originalist terms. Not none, but that was not the central theme. Originalism sort of became a player later on. owing to the work in ways people associate with the Federalist Society in large respect. So that's an example of a view. What I think, I mean, I actually thought they kind of had it right back in the 50s in this respect, but this is something that became a respectable view. And I think to the extent we are able to influence anything, that's the target.
Yeah, I'd like to agree with that. I mean, in the sense that I think, I mean, when you're making a claim, you know, you're making the claim for truth, right? So everyone should listen to it, or at least assess it. But ultimately, so much turns on the legal culture, right? How people think about these matters, what they consider to be acceptable moves. And one of the things about originalism that is you've got from maybe the time period of, let's say 1930 at least, through the 1980s, a period of time where the legal culture regards originalism as just ridiculous, right? It's largely rejected. And now what's happened in the last 20 years is originalism has made a resurgence, right? So, and that's taken, it's going to take time to do that, right? In a way, originalism has always been sort of the popular understanding of the Constitution, the understanding of the people who were fooled by the claims of the Supreme Court that they're just enforcing the Constitution. But in terms of the legal culture, it's only been you know, a couple of decades, and I actually think some of the problems that people point out with originalism will be addressed as more and more work is done with it, and it becomes increasingly accepted. It takes more than just you know, a couple of years for an interpretive methodology and a whole legal movement to have effect.
If I could say, I think the nomenclature of originalism is something that's relatively new, but I don't think the originalist philosophy, understanding it not to focus on what was actually articulated or said at the ratifying convention, but understanding it to be focused upon the original words that were placed in the positive law by the drafters. I think we were all originalists on the bench at one time. I think until the late 1960s, I know in my state, all judges were originalists. They broadly understood, interpretivist, however you wish to put it. As a result, because of this common view, the common premise that was brought to bear, there were very few dissents, very few separate opinions, very few precedents with which any judge could take strong exception. That, of course, is no longer the case. There are now clear-cut lines of division that distinguish judges. There are many dissents now, there are many separate opinions, and with each judicial generation, there are more and more precedents that one or the other camp just can't accept. And I know on my court, I'm thinking about a state court, we do have 50 state courts in the country, as we see the electoral process play itself out, and as we see interpretivists at one point prevail or capture majorities on the court, and then non-interpretivists prevail and capture majorities on the court. I think we have a situation that's ripe for confusion. I think the consequences and implications of an increasingly polarized judiciary for the stability and the integrity of state legal systems and for regard for precedent is extraordinary as we go back and forth between majorities that have a perspective of the judicial role lying at one end of the spectrum, only to be succeeded by majorities that hold perspectives at the other end of the spectrum. I think it's something of great import for the judiciary in the 50 states.
Very quick point. The audience is you. It's law students. The beauty of originalism is it's a standard. An originalist judge says, hold me to these principles, and if I violate them, then hold me accountable. So if the argument is Justice Scalia, you're picking and choosing among methodologies. Sometimes you're an originalist, sometimes traditionalist, sometimes a textualist, sometimes you favor precedent in order to get to the result you want. That's a serious criticism, because after all, Justice Scalia says you've got to hold me to my own standards. Justice Scalia says I'm writing not for my colleagues, but for law students to persuade the next generation. One of the thrills of studying law is that we have the luxury, you know, academics, students, we can be more principled than the judges themselves, and if you're persuaded by any of these criticisms, then resolve that you will do a better job than we, your elders, have done.